On a Tuesday morning in October 2014, a jury of 12 people filed back into Courtroom 7 of the Hartfield County Superior Court and returned a guilty verdict in the first-degree murder trial of a 38-year-old high school science teacher named Thomas Rendell. The verdict was unanimous. The deliberation had lasted 9 hours across 2 days. The judge thanked the jury for their service. The prosecutor shook hands with the victim's family. Thomas Rendell stood very still while the verdict was read, and then he sat down, and then the bailiff came for him, and then the courtroom cleared. That verdict was wrong. Not in the sense that a few people had doubts or that the case had some procedural irregularity that a clever lawyer found years later. It was wrong in the foundational sense, the sense in which the word wrong means something real happened, and what the jury decided was not it. By the time this video ends, you will know exactly how the wrongful conviction of Thomas Rendell was built, piece by piece, from evidence that was either misinterpreted, selectively presented, or in one case, manufactured. And you will understand why, if you had been sitting in that jury box, you might have voted the same way. That last part is the most important part. I am not telling you this story so that you can shake your head at 12 people who got it wrong. I am telling you this story so that you understand the mechanisms, the specific, identifiable, documentable mechanisms through which a jury of ordinary, well-intentioned people can look directly at the evidence and still arrive at the wrong answer. Because those mechanisms are still operating in courtrooms today, and the only protection against them is knowing what they look like. We begin with the verdict. We end with the truth. Everything in between is the exhibit log. The person at the center of this case was a woman named Patricia Wollner, 42 years old, a real estate agent who lived alone in a house she had recently purchased after a divorce, finalized the previous spring. Patricia was found dead in her kitchen on the morning of September 4th, 2014, by her adult daughter, who had come to collect a spare key. The cause of death was a single blunt force trauma to the back of the skull. Time of death? Between 8 and 11 p.m. on September 3rd. The weapon was never found. Thomas Rendell had known Patricia for approximately 3 years through a mutual friend. In 2013, they had a brief romantic involvement that ended, not bitterly, but definitely, and they remained in contact afterward. Patricia's friends described Thomas as having been harder to move on. Thomas maintained from the moment of his arrest through every appeal that he had accepted the end of the relationship honestly. The prosecution's theory? Thomas went to Patricia's house on the evening of September 3rd, intending to confront her about a new relationship. The confrontation turned violent. He killed her and left. The theory was coherent. The timeline was supportable. And it rested on one uncomfortable fact that Thomas could not change. He had no alibi. He said he was home alone, grading student papers, no phone calls, no credit card activity. No witnesses. In a jury room, the absence of an alibi does not prove guilt, but it removes one of the most powerful things a defendant can offer, a concrete counterstory. Without it, the prosecution's story fills the vacuum. He couldn't prove where he was. The prosecution couldn't prove where he was either. The difference was, they didn't have to. Post-Conviction Review Attorney 2018. The second pillar of the prosecution's case was physical evidence. A single strand of hair found on the kitchen floor near the point of impact. The state forensic laboratory analyst, Dr. Marcus Fenn, examined it, and concluded in his written report that the hair was consistent with the hair of Thomas Rendell. That phrase, consistent with, was presented to the jury as evidence of a connection. It was not. And the gap between what it means in a forensic laboratory and what a jury naturally hears when they hear it is the gap through which this wrongful conviction passed. Consistent with, in the specific technical vocabulary of microscopic hair analysis, means that two samples share observable characteristics under a microscope. It does not mean they came from the same person. It means they look similar. Two hairs from two entirely different individuals can be consistent with each other under microscopic analysis. This is not controversial science. It is the established limitation of the method. The FBI acknowledged it formally in 2015, 1 year after Thomas Rendell's conviction, in a sweeping review that found forensic analysts had for decades testified about microscopic hair analysis in language that overstated its scientific validity. The review covered thousands of cases. Thomas Rendell's was among them. During the trial, Dr. Fenn was asked whether the hair could have come from Thomas Rendell. He said yes. He was asked whether it was consistent with Thomas Rendell's hair. He said yes. He was not asked what percentage of the general population would have hair consistent with Thomas Rendell's under the same analysis. He was not asked whether consistent with constituted scientific identification. He was not challenged on the method's limitations. The defense did not retain a forensic science expert. The jury heard the word consistent in the same courtroom where a murder had been described in graphic detail, and they filed it away as confirmation rather than qualification. The most damaging testimony came from a neighbor named Sandra Okonkwo, who lived 2 houses from Patricia. Sandra told investigators and then the jury that at approximately 9:15 p.m. on the night of September 3rd, she had been walking her dog past Patricia's house and had seen a car she recognized as Thomas Rendell's, a dark blue Toyota Camry with a distinctive dent in the rear quarter panel, parked outside. She was certain of the time, she said, because she had checked her watch. This testimony provided the crucial link the prosecution needed. Thomas was at Patricia's house during the kill window. Combined with motive and the hair, the triangle was complete. What the jury didn't know was that Sandra's account had 2 quiet fractures. The first, in her initial statement to officers the morning after the murder, she described seeing a car she thought might be familiar. The specific time reference and the certainty only appeared in her formal witness interview 4 days later, after she had apparently spoken to another neighbor who had mentioned Thomas Rendell was a suspect. The certainty grew in the space between those 2 conversations. The second fracture was more concrete. Sandra Okonkwo said she was at Patricia's house at 9:15 p.m. Her cell phone records, not subpoenaed during the original investigation, but obtained during the post-conviction review, showed a call made from her landline at home at 9:12 p.m. Her home was a 4-minute walk from Patricia's house. This does not make the story impossible. It makes it difficult. Difficult was something the jury never had the chance to weigh because nobody put the phone records in front of them. In 2016, a journalism student named Priya Kapoor wrote a senior thesis on wrongful conviction patterns in the county's court history. Through a public records request, she obtained documents related to the Rendell case. Among them, a set of handwritten notes from the lead detective, Howard Briley. One entry, dated September 8, 2014, 5 days after Patricia's death and before Thomas's arrest, read, "Followed up on alternate vehicle sighting. Neighbor on adjacent street reports, dark-colored sedan, possibly non-Toyota, outside Wollner property between 8:30 and 9 p.m. Unable to confirm make. Not pursuing further. Primary suspect established. An alternate vehicle. An alternate window. Not pursued." Not because the detective was malicious. The note itself reflects a detective trying to be thorough and choosing, under time and resource pressure, to stop. The phrase "primary suspect established" is the phrase of a case that has already decided its direction. It is the point at which investigative openness closes and the confirmation of a conclusion begins. It is one of the most common structural features of wrongful conviction cases, and it is almost never the product of bad intent. It is the product of finite resources applied to a theory that has gathered enough momentum to feel like certainty. Priya Kapoor gave the notes to an innocence organization. They filed a petition for post-conviction review in 2017. Thomas Rendell's conviction was vacated in 2019. He had served 5 years. He was 43. The detective's notepad, sitting in a box for 3 years, had contained the thread that unraveled everything. And nobody had looked for it until a student filed a public records request for a class assignment. On a Tuesday morning in October 2014, a jury of 12 people returned a unanimous guilty verdict in the murder trial of Thomas Rendell. They had heard a motive theory. They had heard hair analysis testimony from a credentialed forensic analyst using language they understood as confirmation. They had heard a neighbor describe the defendant's car parked at the scene during the relevant window. They had heard the defendant admit he had no alibi. They had done their job. They had weighed what was given to them. They had not heard about the FBI's own assessment of microscopic hair analysis. And they had not heard Sandra Okonkwo's initial statement or seen her phone records. They had not heard about the alternate vehicle sighting in Detective Briley's personal notes. They had not heard any of these things because the trial, as trials do, presented a curated version of the available information. And the curation had not been equal. The prosecution's evidence was complete. The defense's counter-evidence was incomplete. The jury decided with what they had. The actual killer of Patricia Wollner has not been identified. The case is open technically and cold practically. Patricia's daughter does not have an answer. Thomas Rendell is free and 50 years old and has spoken publicly about the experience of incarceration with the specific, measured steadiness of a man who has decided that anger is too expensive to sustain. He teaches again. He has a classroom. He grades papers in the evenings. This time, when his whereabouts are unaccounted for, it is because he is doing what people do when no one is watching, living quietly without consequence, the way the rest of us do every day.